unique.
You are what you do. You can say any amount of things that you want to say, but what you do is what everybody sees.
People are like, "Oh, I'm just going to JV it. Like, let's just JV it." Like, what the hell does that mean?
I cannot tell you how excited I am to hang out with you guys today. So thank you so much.
Well, then that end buyer could come back and say, "Well, I didn't fully understand that it was subject to."
That's not a thing. Like, the SEC has thought of all of these things. They've been here since 1932.
And you can do what you want with your property.
Buyers have time, they have negotiating power, they have options.
Oh my gosh, I am blown away by your inexperience, and they've been in business 20 years.
And that includes things other people put on your property, right? It's your property, okay? Suddenly Cousin Jimmy's in a lawsuit.
A novation is replacing one contract or one obligation with another.
Out with the old, in with the new.
Yes.
Hey, everybody. Welcome to the show. Today, we're talking about what role do they play? That is attorney versus the transaction coordinator in real estate. I'm Andy Fowler, and I'm here with Sean St. Clair. If you're new to the show, make sure to give us a like and follow us on our channels. We are on Facebook. We are on Twitter, now known as X, and we are on YouTube. On YouTube, we are at InRem Podcast. That is at InRem Podcast. Make sure to subscribe. We are also available on audio podcasts as well, Spotify and Apple Podcasts. So go there, leave us a review, download the podcast. That helps us out a lot. We really appreciate it. With that, let's go to Sean, who has our legal update.
Thank you, Andy. So my legal update today continues with my what if questions I've been throwing out there. So today, the what if question is, what if someone claims title to or an interest in real property that you own? So you own a piece of property, and next thing you know, somebody's coming out of the woodwork saying, "Oh, wait a minute, I own that," or "I'm claiming some form of interest in that property." Maybe it's an easement across that property, whatever it may be. They're claiming some adverse interest to your ownership of the property. What do you do? And we had Brian Locker on a few weeks back, and we talked a little bit about adverse possession and quiet title claims, but we'll get in that a little further here with this question. So ultimately, what you're going to have to do is pursue a quiet title action. That's what we call it in Arizona. Other states call it declaratory judgment actions or declaratory action, whereby you're going to declare or ask the court to declare who owns the real estate. So in Arizona, it's quiet title. And in Arizona, there's a condition precedent to your ability to recover attorney's fees in quiet title actions. And what that condition says is that first, you have to send to the party that's claiming that adverse interest a letter basically explaining that you have a greater interest in the property to them, that if they don't stop claiming an interest in your property, or they continue to claim an interest in your property, you're going to have to file a lawsuit against them. And you're going to give them a chance, though, before the filing of the lawsuit, to clear the air and acknowledge that you are the owner of the property. And the way that they're going to do that is they're going to execute a quitclaim deed that you're going to deliver to them with the letter that says, basically, here, I'm going to quitclaim any interest that I have in the property. I'm going to hand over to you by this quitclaim deed, and I'm going to acknowledge you as the rightful owner, full 100% fee simple owner of this property without any adverse claim by me. And so they execute that quitclaim deed and they return it. The letter will give them 20 days to do that. If they do not do that within 20 days, then you can go and file your quiet title action. And if you're successful on the quiet title action, then you have the ability to recover attorney's fees against them. So basically, if somebody's claiming an adverse interest in your property in Arizona, you're going to want to send a letter to them in advance, advising them that you have a greater interest than them, and giving them the opportunity to execute a quitclaim deed, which will basically eliminate their adverse claim. And if they don't execute that quitclaim deed in 20 days, then you have the ability to file a lawsuit and pursue your attorney's fees if you're successful in that quiet title lawsuit. One last thing I will say is, in addition to the quitclaim deed, you also have to deliver $5 for the recording costs and expense and inconvenience of having to execute the quitclaim deed. So don't forget the $5. So it's a letter, quitclaim deed, and $5. But if you do that, you wait your 20 days, you can file your quiet title action. And if you're successful, you can recover your attorney's fees in that lawsuit.
One thing I think is worth noting in this, and I think is often left undiscussed, and I only really think of it because I ran into this one time in a case, which is make sure you have the quitclaim deed right. Nobody ever thinks about this, but there's actually a statute in Arizona which sets forth what goes into a quitclaim deed. And usually just about every form that you get of a quitclaim deed is going to comply with that. But I've seen lawyers make the case that maybe it was because you didn't include the legal description, or you didn't do something that was necessary, a necessary component of the quitclaim deed itself. And because you failed to provide that adequately, then you basically waived your right or don't have a right to seek attorney's fees. And of course, guess what happens? You never learn that you've screwed up that portion until far down the lawsuit, when it's way too late to cure your problem, right?
Right. Well, and you know, I kind of made it seem simple: a letter, a quitclaim deed, $5. But let's say somebody's claiming an easement interest in the property. Well, you probably now need to go and get a surveyor and figure out, what the legal description is for that, potential easement interest, and then attach that to the quitclaim deed and say, okay, you're making a claim as to this strip of land. We want you to quitclaim that, interest to us and eliminate that. And so, it's those types of issues that come up, and, a surveyor is going to cost a few $1,000s in Arizona. And so there is some level of expense and complexity to, making this happen prior to the filing of a lawsuit. But, if you own real estate, part of owning real estate is incurring the expenses necessary to protect, improve, and maintain that real estate. And that's just one way you have to do it. Make sure there's no adverse claims out there.
Yeah, 100%. So yeah, make sure you've got that legal description wrong, because again, the point of that letter is to give, like what you said, Sean, the chance to clear the air. So you have to give them an actual legitimate chance to clear the air. If you send over a wonky quitclaim deed with a legal description that doesn't even purport to address exactly where that is, then, arguably you haven't done that. So yeah, that would maybe where you end up needing a surveyor and can't just rely on a copy and paste and some legal description with the assessor or recorder.
And one last thing that I'll throw out there is this assumes, and my, analysis here assumes that there's no title insurance, right?
Right.
So, if somebody's claiming an adverse interest in my real estate, probably the first thing that I'm going to do is, if I have an insured, purchase of the property, I'm going to tender it to my title insurance carrier, and then they'll start that process if I'm insured. If it's a risk or something that's not insured, then at that point, you're going to send the quitclaim. So generally, you're going to want to tender it to your title insurance carrier first, but if they don't accept it, then you're going to have to go through that, quitclaim and then quiet title process.
Right. All right. With that, let's talk about a few announcements here with the NREM podcast. Tomorrow, every Wednesday at 5:00 p.m. Arizona time, we host the Creative Finance Collective. That is a collection of professionals, attorneys throughout the country that are and focus their practice in not exclusively, but in creative financing, and are in that area and approach it from a variety of jurisdictions. Why do we do that? Well, we do that because we just enjoy meeting lawyers and getting together with them and learning how they're doing it and how they can make our practice better. But we also do it for you, the listener. We make ourselves available for the entirety of the hour. It's an open forum for questions, a chance for you to ask lawyers from a variety of different states how they're approaching creative financing and dealing with different issues. So make sure to be a part of that. It's really a valuable thing to do, and it's free to you, the listener. Tomorrow, 5:00 p.m. Arizona time. Make sure to be there. You can find it on YouTube, Facebook, or Twitter, any one of them, and it's live. Just stick with us and watch and ask your questions, and we'll be there for you. We're also going to take any questions that you have today. Usually we take those in the final 15 minutes of the show. I'll turn it over to Mayu, who can give you instructions on how to go about posting your questions.
Everyone, we are live on the INREM podcast. As you know, Andy, Sean, and our guests are here to answer your questions live on the show. So that's right, we do monitor our comments for your questions. We only take about 10 to 15 minutes at the end of the show, so don't wait. If you're watching the INREM podcast live from our YouTube or Facebook pages and you do have a question, go ahead and drop it in the comments, and then we'll try to get to all of them at the end of the podcast. So I'll go ahead and turn it back to you, Andy and Sean. Tell us a little bit more about our topic today.
All right. Thank you, Mayu. With that, let's talk about our topic. So we're talking about attorney versus transaction coordinator. The difference is how they work together, what they are, and what roles they play in the real estate transaction. And with us to discuss that topic is our guest, Andrew Gurvey. Andrew, thanks so much for joining us.
Thanks for having me.
Andrew, tell us about your law firm, your law practice, and how you got into doing what you do.
I'm a Georgia licensed attorney. I've been practicing in Georgia for about 22 years. Started off with a little firm in rural Georgia doing subprime refinances before the crash. And over all of the decades, just been getting more and more entrenched in creative deals. And we handle everything from every corner of the state. Commercial, residential, refinances, purchases, everything with real estate except litigation. We do it all.
Now, Andrew, I understand you also serve as the director of real estate for Habitat for Humanity in the Atlanta chapter. Tell us a little bit about that.
I've been doing that for about 7 years. Director of real estate. I handle all their acquisitions, purchases, and also some aspect of legal counsel, document review, closings, you name it.
So you have a hobby for 3D puzzles. Tell us about that.
I'm not sure where you're getting all this information from. We'll have to work on that after the fact. Just a hobby for collecting interlocking wooden puzzles. If you know them, then they're out there. Some of them are expensive, very intriguing craftsmen that create them.
Now, I know that you kind of have a niche for real estate closings. What got you into doing real estate specifically? Was it just like the rest of us in law? We go get our first job out of law school, and whatever that is that they told us to do, we just get good at and we fall into it? Or how'd you kind of develop that niche?
It was pure accident. I think, I don't know how it is for most people out of law school, but I don't think you really learn how to practice. It's more of, I felt it was teaching, at least my school, was, teaching the academic side. So I didn't really know what to do getting out. And I thought I wanted to follow with juvenile law. I originally got into this going to law school part-time in the evenings while I was a child abuse investigator for Department of Family and Children's Services. So, and the day I was, investigating child abuse, taking kids away from their parents, putting them into foster care, then going to law school at night. So I wanted to go that route. Couldn't find anybody at the time that wanted to mentor me, take me under their wing. I got in a position with the DA's office in Fulton County doing drug trafficking work, then thought I wanted to maybe go into that area. And just by chance, I stumbled across a position looking, in a firm out in rural Georgia, looking for an attorney to handle closings. It was someone I went to law school with that hadn't passed the bar, and he was managing the office. And the next thing you know, I'm taking 20 files and driving through rural Georgia doing closings, and learned that way. 6 months later, I hung my own shingle and said, I can do this better without driving around. And next thing you know, I've got a growing office with 3 attorneys and 9 paralegals, and then started getting involved in REO work. And here we are.
So one of the things that we're wanting to do, obviously, in this episode is distinguish the differences between an attorney and a transaction coordinator, and outline the ways in which they can be a part of the real estate deal and the real estate closing. Now, some of that is kind of defining terms and setting out kind of experience and everything else. So the folks that listen to our shows, a lot of them are in Arizona, as we're Arizona attorneys, but a lot of them aren't. They come from a variety of different states. Some of those states might be attorney closing states, like Georgia. Some of those might be like our state, Arizona, where it's title company closing. But you'll see a role that lawyers and transaction coordinators may play. Spell out for our listener, just so they have an idea. Obviously, Sean and I know, but give us an idea about your background in training as an attorney, what it looked like to go from aspiring law student to attorney.
Which aspect of training? You mean going through like all these books?
Yeah, all the ones behind you. Yeah.
Yes, that are real books. I mean, the training as an attorney, is extensive. In fact, I was telling someone the other day about the orientation day 1 with the dean of the school, which was, telling everybody in the conference room is look around you. 1 out of 5 people that are there are not going to be there by the end of the semester. That there are teachers that specifically look to weed you out, that the work is so exhaustive. I want you to prepare 10 cases or 100 pages in a book that are as thin as rice paper, and be ready, the next class. So Tuesday, Wednesday, Friday classes, you have a day to do that, and then you have 5 classes. So you're reading 500 pages, and not just reading them, it's, understanding and taking notes, briefing them. And if you're not ready, which happened only once in my law school career, is I had a professor kick me out of class.
Oh.
And, I'm sorry, Mr. Gurvey, if you're not prepared, then you don't deserve to be in this class. We're going to wait for you to leave. And, it was, a production. But it's, it's understanding the law. It was a training of where to find it, to understand, every aspect about it. What, happens from statute to cases, what's precedence, what's practice. It's one thing to know how something is done. It's another thing to understand the implications.
And if that wasn't enough, after they gave you that diploma and say, congratulations, they said, oh, by the way, you're still not a lawyer. You've got to go take this test, right?
It was, the bar exam was utter hell. It's one that, I can't really compare it to anything. And nobody really tells you that, I'll just go to law school. Or I'll watch some movie about somebody going to law school or taking the bar. It's not that easy. And I understand there's some states that you even can waive in. There used to be, I guess, some older provisions in Georgia where if you practiced in the courts, I know some, paralegals that ended up moving up and are now judges that didn't go to law school. Mm-hmm. And I don't know how that is nationwide, but yeah, the bar is hell.
And then once you pass the bar, you're still not admitted, right? Because there's this thing called character and fitness.
Yeah, the background checks.
Yeah,
and, pint of blood and fingerprinting, and then getting other attorneys to say, yeah, we vouch for you, and it's a process, which. In retrospect, you would think that somebody that goes through all of that would be, people that you could rely on and, trust to the ends of the earth. But then you hear occasional stories of those attorneys that, should have never, allowed to
Right.
practice at all, and wondering, it's like, how did they get through that? But yeah,
Yeah, there's bad apples everywhere, unfortunately.
right.
Yeah.
Same thing with doctors and
Yeah.
you name it. Yeah.
So once you're licensed, so you're licensed in Georgia, Andy and I are licensed in Arizona. Once you're licensed,
Oh, and that's not the end of it.
oh, that's not the end of it. Let's yeah.
There's the continuing legal education
Oh,
classes
right.
that you have to take, which, it's funny though, is, a bunch of years ago, I also got my license for a salesperson to be a realtor, which is now inactive. And they required, after you were able to do that, so many hours of continuing education classes, which I said, do I still need to do that? I'm an attorney. And they're like, yes, you need the hours. I said, wait, so I'm an attorney who is accredited to the point of where I can teach your CE classes, but I still need to take the CE classes to be able to keep my license as a realtor. And, it made no sense.
On top of the CLE classes, you're already
On top.
Yes.
And there was no coordination to say, oh, I can take this one class on contracts to satisfy my attorney requirements, but I need a different class on contracts for my CE license, realtor, credits. So yeah, but it goes on. So that's annual, along with the fees that you pay to the bar, which, if you're poor, you can waive them and all of that. And then, depending on which area of law that you want to go into, you could certainly foolishly do it without the insurance, the E&O insurance, which goes up and up every year. Real estate is more expensive than I think most any other area. I forgot which is the second most expensive E&O insurance. And then for those that I think Andy had mentioned, Georgia's one of those attorney states. I know South Carolina's one, Maryland's another. But we're also agents of the title insurance companies. So we also have our practice subjected to their scrutiny. They audit all of our accounts and our business, and, it's another eye looking over us, every day. It's a pain.
Now, once you're licensed though in Georgia, your practice is limited to Georgia, right? You can't go across state lines and close real estate transactions in Alabama, for example, right? I mean, you would have to be licensed in Alabama.
Correct. So yes and no, which is,
okay.
Well, there's the aspect which is a little peculiar. So when I first got licensed in Georgia, of course, everything goes through the Georgia, Supreme Court. But I also ended up getting approved in the federal courts. So that's the other nuance to where I could practice at a federal level because of my, license in the federal court. So that could cross state lines. But as far as the basics for closings, my practice is limited only to Georgia. I have done work in other states on the commercial side of things, but that was at another firm. And we did some commercial transactions, I think in, let's say, Texas, California, Colorado, New York.
Yeah. And there's special rules and exemptions that apply for,
And I don't know how that happened, but, nobody, there were a bunch of other attorneys. Actually, it was a firm that I worked with for a little time that did have a national presence. So,
right.
But yeah.
So what, as far as attorneys go, what are the rules that, govern attorneys and their conduct?
What are the rules? Don't do anything bad.
All right. I mean, we have a special set of ethical rules, right? I mean,
there's an extensive, here in Georgia, there's an extensive set of rules that, are to be followed. And, the bar is always sitting there in the background to take complaints, to serve, to monitor, how an attorney acts. There's quite a bit of scrutiny, as well as that all of our business sort of functions through our, trust accounts. And in fact, like my trust account that I have the many that I've had, it's not just my name on it, it's the bar's name on it, which is one of the reasons that they have access to it. So, but yeah, there's an exhaustive, volume of rules to govern not just the practice, but how you act, how you interact with clients, who you represent, what their interests are, for sure.
So some of where we're going here, obviously, is painting the picture of just how highly regulated of a profession the practice of law is, and what goes into the education and being an attorney itself. So let's flip to talking about, in order to distinguish, what is a transaction coordinator?
You're looking to me for that?
Yes.
A transaction coordinator is a person typically that's been hired to be the go-between between individuals in a transaction and the closing office, whether it be a title company or a law firm, a closing attorney. So they might be hired by the realtor to be the coordinator to handle their communications, so they don't, personal assistant, or it might be the wholesaler or the assignor, the signee, whoever it is involved that wants to basically have a helper.
Now, do you regularly work with transaction coordinators in your closing practice?
There's a few, and it's become more prevalent. I hear, I think you guys also hear of people asking about it. I think there's probably more videos out there where people are being trained to think that they can't do real estate without having a transaction coordinator. That's part of their initial team that they build is, go find a closing attorney, go find a title company, get your transaction coordinator, in play. And, so we see them more and more often.
So what have you found to be the benefits of having a transaction coordinator involved in a closing?
It's occasionally it's having one point of contact, but it's somebody that is, should be keeping up with the parties and also having a hand in, getting documentation and getting information to us. So that's been helpful for sure.
So I suppose the answer to this question could be yes. Theoretically, the lawyer in me is thinking that this theoretically could be yes. But do transaction coordinators, are they attorneys typically with the ability to practice law?
I have yet to come across a transaction coordinator that promoted themselves as also being an attorney, whether they were practicing, licensed, or a former attorney. So I don't, of the ones I've come across, I have not heard of any type of certification or licensing or anything like that.
So Andy used the, definition of the practice of law. What do you understand the practice of law to mean? What does that look like,
So Georgia has an interesting and vague, semi-vague, definition. So there's the practice of law that would be representing a client in court and formally saying, okay, I am an attorney and I'm going to speak on behalf of this person. That would be the practice of law. It would be filing something in court, a legal document, but at least also here in Georgia, it's the creation of legal documents is considered to be the practice of law. So when you get into contracts, the contract is a legal document of which attorneys have the ability to create it on behalf of somebody else. That doesn't mean that a person can't create their own contract. You can, and I've talked about this before, two people, can enter into a contract, they can create it, they can write it on a napkin. As long as all the elements are there, it's valid. But if you're going to do it for somebody else, you have to be an attorney. If you are filling in a form, there's an exception in the Georgia Code that if you are a licensed agent, a realtor, a broker, then you can fill in pre-printed forms, and that's not violating the law. You're doing what that you're allowed to. It's that carved out little niche of I'm completing this form for somebody else. That's the parameters. But anything beyond that is considered, practicing law.
Yeah. So Arizona's similar, except we have a few more categories of people that can be involved in the creation of legal documents. And it's ours says, someone who for compensation prepares legal documents for someone else. And that is normally the practice of law reserved to attorneys, but we allow, and we're not limited to the filling out of pre-printed forms. We allow real estate licensees, so real estate agents to prepare contracts. And we also allow, and we have this subset of category of professionals called certified legal document preparers.
Oh.
And they are allowed, they can't give legal advice, but they are allowed to prepare legal documents. They can give legal information, but they can't give specific legal advice, and they can prepare legal documents on behalf of whoever's, employed them to do that. So, in Arizona, we have those, three categories. So, anyone who for compensation is going to, prepare legal documents. The categories are attorney, certified legal document preparer, and real estate licensee. Anybody outside of that, isn't allowed. Now, we also have an exception for, because we're a title closing state, we have an exception for recorded instruments. So deeds of trust, things like that, where we will not allow real estate agents or licensees to do that, but we will allow title companies, licensed title companies, escrow agents to prepare, the warranty deed, the deed of trust, those types of documents, along with certified legal document preparers and attorneys. So those are, some of the exceptions we have in Arizona. I think every state's going to be a little, unique on that. But it's those categories of, professionals who are licensed. I mean, certified legal document preparers have to go through a testing, and they have to be certified, and,
you don't get to just declare yourself certified legal document preparer and therefore fall within the exception, right?
Right.
So if I have land and I want to gift it to anybody, a kid of mine or a neighbor, a friend, and I just, so here in Georgia, I would grab a quitclaim deed off of the internet and fill it out and go record it. Can I go to a certified legal document preparer and have them prepare a quitclaim deed? So it's even if it's but I can't go to a realtor and do that because it's going to be recorded.
Correct.
But I could go to a realtor and have them write up a contract for me to sell or transfer.
That's right. Yeah.
All right. So now the certified legal document preparer can't give legal advice. If I go to them and I say, I need to do something to transfer property, do I need to do a quitclaim deed or do I need a limited warranty deed? Which one should I use? Can they give an answer?
Yes and no. So they likely should refer you out to seek specific legal advice, but they can give legal information, and they can say, well, if a person wants to convey property, they can do it by a quitclaim deed, and here's what a quitclaim deed does. And if they want to do it by a warranty deed, here's what a warranty deed does, and then say it's up to your decision which you want to use, if that makes sense. So that would be legal information as opposed to legal advice. But they can provide that as a certified legal document preparer.
Is the preparer doing things more extensively, like wills or trusts?
Yep.
Wow.
They can do all of that. Wills, trusts. Yeah. And so it's a subset of categories. And our office actually does a lot of work with certified legal document preparers. We teach regularly at their annual conference. It's just a subset of professionals who,
Right.
are handling, legal.
And how long would it take for me to become a certified legal document preparer in Arizona?
It's going to be a process. So I don't know the exact
weekend.
No. So you have to go through and you have to go through a background check. You have to pass a little exam, and then you have to be mentored for, I want to say 6 months, maybe a year.
6 months.
Under and I could have those dates wrong, but you have to be mentored basically under somebody who's, certified, and so you can work under them. And then once you do put in your time, then you can officially, hang your own shingle and, go out and work on your own behalf.
Wow.
Yeah.
Very cool.
I think what's interesting though, in even in that context, and depending on what the state law is, but the confusion that oftentimes I think you run into is the belief that, well, because there are these exceptions, that must not be the practice of law. And it's like, well, no, that is the practice of law. The law is just allowing for these unique exceptions, this particular professional to do these things within that. We're saying that's okay within these exceptions. And oftentimes I think the unwise thing to do is assume the exceptions mean that this isn't the practice of law. So all is in play with regard to some of this. Have you seen, or where do you see a blurring of lines? It doesn't sound like you have document preparers, so to speak, in Georgia, but you've got transaction coordinators. Where do you see the blurring of the lines where there's not an appreciation for the practice of law?
Everywhere. Nobody, I run across investors, wholesalers that, have no respect. I mean, it's everybody, they don't have no respect for attorneys, that they look at, a closing attorney, our practice as, like a drive-through, fast food. And there are some experienced, investors that know what they're doing, but, the vast majority of them, are using, contracts that are one page, or, that have deeds that, barely, pass any standard, that they're just, getting people to sign, or that the follow through is not really there, or they think that, oh, I'll handle this. And they're just leaving out components that are important. We see stuff record. I mean, I used to say that, you can go to the clerk's office and there'll be signs in every clerk's office. Georgia has over 100 different counties, and you'll see, we can't give legal advice, and they generally don't. Now the clerks will know practice of this has to happen, and you have to file this and everything. But I used to say that, if you wanted to record your VCR instructions in the county real estate records, you could do that, because I see things recorded all the time that should never have been recorded. They're missing a notary stamp. They're missing a witness. The date's not on there. The legal description wasn't attached. Why are these recorded? Just because somebody paid $25? That just doesn't, cut it. But at the same time, there are people that are doing the same things. They're grabbing documents because they think they're going to save some money off of the internet, out of an Office Depot, and thinking it's sufficient. The recording requirements are not the same for every state. Georgia doesn't allow acknowledgments. And that's one of the big things we come across, is somebody gets something notarized in California and they just acknowledge the signature versus witness it. And, so technically that can't be recorded. But then you end up with something where, and I've had this before, it's an acknowledged deed. We can't record it. Now they're dead. Now what do? You call your underwriter and you figure out if you can insure over it. but there's that gap between respecting the work that we do and the analysis versus somebody that's just trying to, shove a square peg through a round hole.
Now, you and I, and this is kind of how this show originated. You and I have kind of, tag team responses on social media regarding, where somebody has commented and said, "Hey, can you refer me to an attorney to provide legal advice?" And then a bunch of investors and other people have chimed in and, "Oh, you don't need an attorney. Contact a transaction coordinator." And that's a pet peeve of mine. And I've jumped in and, commented and asked even questions like, well, why would they need a transaction coordinator? When did they become, able to offer legal advice? So talk to us about those types of things when you see them and what kind of has been your response and how you've handled those situations.
So, most of the stuff like we've seen is on social media, somebody saying, describing a situation where really they need an attorney or a title company, where that would be more sufficient. And I think a couple of them have been, well, I need a contract. Where can I get a contract? And then somebody speaks up, I'm a transaction coordinator, I can help you with that. And, at least for Georgia, that wouldn't fly. Assuming that the transaction coordinator isn't an attorney or a realtor. So, certainly we've dug into, our responses on that. On the practical side, for the transaction coordinators I've dealt with, they're really doing the coordinating of the transaction. They're coming in, they're introducing, hi, we've been hired by, or we represent, we're, facilitating this for, here's all the information, here are the contracts, here's their corporate documents, all of that. Great. Some have been a little overactive and, it's 5 phone calls a day, following up and, to the point of where I just want to, reach through the computer and strangle them. Like, you don't understand, we haven't gotten this information yet. As soon as we do, I promise we'll get it to you. But they really haven't been providing any advice. They haven't been providing anything that I think would blur that line. But it's been, and I always preface it, I don't know where these transaction coordinators are. I don't know where somebody's asking for a contract, but I'm cognizant of the fact that if you're in certain places, you're probably going to need something that's provided by an attorney or filled out by a realtor. And look, if a transaction coordinator has a whole bunch of documents, in fact, it's funny, we did a closing, some time ago, and the transaction coordinator provided all these documents to be signed at closing for the subject to closing. And, they were similar to what we had, a different format, so it was a duplication. But I was like, okay, great. I asked the buyer, I said, where did these come from? They're like, well, the transaction coordinator, gave it. It's part of their standard. And I'm like, okay, that's new, that's different. Were they crossing any lines? These were just, supportive administrative documents, really. Nothing that was too much, but it's there. I mean, you see it, somebody, oh, I can handle this for you. No, you can't.
Right. So if a transaction coordinator came to you and was like, hey, I'm going to prepare the deed or the promissory note or the deed of trust for the wrap, what would be your response to that?
I think I'd laugh.
Okay.
I mean, it's just, what the hell are you, this is not your job. At least here in Georgia, that would not be their job. A transaction coordinator is not the closing attorney. They're not the title company. They're not, to take a term from the HUD form. They're not the settlement, location, place of settlement, whatever it is. They're just the coordinator. They're not a drafter, a certified drafter. And maybe it's just people have become, comfortable with what they've been asked to do and thinking, and I know it is as an entrepreneur that you look to see where you can, it's the buzz phrase, provide value.
Mhm.
Okay, so everyone's like, oh, what other service can I do? If I'm a McDonald's, oh, I'm also gonna, I'm making burgers. I'm gonna provide a hot dog. And we're gonna do tacos now. How about pizza? It's the coordinators. We're not just gonna coordinate. I can provide this contract. I can provide this document. Drafting a note, that should be coming from the lender, or that should be coming from, the borrower, that's fine, or the seller, depending on where the financing is coming from. Helping them draft it, you go to the attorney, you go to the title company. And most of the title companies that I've come across have attorneys that are in the background preparing the documents because they're important. It's not just well, I don't know what to put in this blank, so I'm just going to leave it blank. No, it's there for a reason. Fill it out. What's the default rate? Well, I don't know what a default rate is, so we're just not going to have it. Okay, well, great. You're lending, a couple $100,000, no default rate. I'll take that loan.
So one of the problems I think people don't appreciate, with all good things, there's also kind of a hidden problem with it. And you mentioned before social media and the ability to communicate in groups of like-minded people, like-minded investors that are doing things. And there's an ease on social media to ask for help. And there's also an ease for people to say, yeah, I can help you. But one of the things that I think people get frustrated with, but don't appreciate from the lawyer's perspective, and we just went into kind of a lengthy discussion at the beginning of this podcast about how highly regulated the practice of law is. And one of those regulations regards our ethical obligations as an attorney that govern us in ways you, the listener, probably haven't even contemplated, even down to how we can solicit you, even how we can ask for work, even how we can market ourselves. So while it is true that a transaction coordinator in some part of the universe is not bound by any ethical obligation and can respond to your request for help, just because lawyers are silent does not mean they don't want to help you. It just means they're bound by certain rules and obligations and everything else, and understand that dynamic in the social media process. I think some of that's lost. I think people don't hear from lawyers and just automatically assume, well, they're just too busy and this deal's not big enough for them, so they don't want to help. It's like, no, we have limitations on how we can communicate with you. And when people say, go find a lawyer in your state, they actually mean that. Find a lawyer in your state, vet this, and figure that out.
Sure. I mean, it's, and we're probably too busy anyway. Or we don't, or we don't believe in your cause. I hear people all the time. We want to do X, Y, and Z. Okay, good luck with that. But there is, I don't know, at least there's not in Georgia. Is there any state that has licensing or supervision or a definition of transaction coordinator?
Boy, not that I'm aware of.
Well, Arizona's not licensed them, but the Department of Real Estate in Arizona has published policies as to what they see as the role of a transaction coordinator, as opposed to a real estate licensee, as opposed to a title company, as opposed to an attorney.
Okay.
And defined basically where a transaction coordinator would be crossing the line into those regulated areas. So the Department of Real Estate said, yeah, you can have unlicensed individuals who act as transaction coordinators, but they're doing exactly what you're saying, Andrew. They are the go-betweens. They are doing the administrative, ministerial aspects of the transaction, making sure that everyone's being communicated with, making sure that people are getting scheduled, they're there, the documents are getting to the proper parties, and everything is flowing in a transaction the way it should go. But here in Arizona, the Department of Real Estate has said, they can't be filling out a real estate transaction or a
Right.
contract, right? Because that would be either the practice of real estate or the practice of law. And so, we do have, while there's no licensing, we do have some policy statements defining those roles.
What about privacy issues?
There is no privacy with transaction coordinators, right?
That's it's something I've been thinking about, more so is, these are the people that introduce the transaction. Typically, they'd be contacting the title company and, hey, here's the buyer, here's the seller information, here's the contract. But they're not in the transaction whatsoever. So, is the practice, is it where the title companies, the closing attorneys should start having forms where the transaction coordinator is signing, saying, or even the buyer and seller saying, I am authorizing you to share my information with the transaction coordinator, and I agree to hold you harmless should this person who's not bound by any ethical, moral, licensing, should they disclose this, I'm not going to hold you harmless, or something like that.
Right. I think as to us and our ethical duty, if the transaction coordinator is acting as an agent to, one of our clients, that would be protected as to us and our disclosure of the information. But to your point, if the transaction coordinator wanted to disclose our communications with them, they're not under any ethical or legal duty to keep those communications silent. So a disclosure or, a authorization from the actual buyer or seller, whoever, we're handling the transaction for, and in your case, probably both, is probably a wise thing.
Right.
Yeah.
I think we have a question, Maya. What is the question?
Sure, we just have one small question today. Aren't certified legal document prepare programs mostly targeted at family law matters?
So I'll jump in there because, of course, Andrew, you don't have them in Georgia, so you're probably like, I don't know, like what, Okay, so it's a great question because in addition, and maybe this is where some of the confusion is if they're referring to Arizona, but and I didn't get into it because it doesn't apply in the real estate context, but in addition to certified legal document preparers in Arizona, we also have this other category that's somewhere between an attorney and a certified legal document preparer here in Arizona that's called a legal paraprofessional. And a legal paraprofessional can become certified in different, and it's very limited, but they can become certified in different practice areas. One of those practice areas is family law. And there's a more extensive testing than a certified legal document preparer, less extensive than, say, a bar exam, but they have to pass a general law test and then a family law test. And once they pass that, they can actually represent, provide legal advice, appear in court, and prepare documents on behalf of family law clients, with the exception of any family law matter in which the ownership of a business is at issue. If ownership of a business is at issue, they can't be involved in that family law matter. But any other family law matter, they can actually essentially serve as counsel. Even though they're not attorneys, they can serve as counsel in those family law matters. So yes, family law is a very targeted thing for certified legal document preparers, and in Arizona, this, legal paraprofessional license. But in Arizona, certified legal document preparers, and my understanding, and I've done a decent amount of investigation and research on this issue actually, outside of Arizona, is it's not generally going to be limited. Certified legal document preparers are generally not going to be limited to family law. They can prepare pretty much any legal document out there. If it's a legal document, they can put it together and prepare it on behalf of their customer or client. And so to answer the question, no, they're not limited to family law, but there is this other group that potentially is only limited to family law. There's a few other areas that they can practice in outside of family law if they get the right certification, but family law is the big one.
So I know that there's there's differences obviously between Arizona and Georgia, and I think they're good comparisons because one is a lawyer closing state and one isn't. But it sounds like, and you guys correct me if I'm wrong, that there seems to be pretty close agreement as to what the transaction coordinator's role is in a real estate transaction, whether it's a lawyer closing state or not, which is kind of an administrative role. I mean, do you see, I guess this is a question for Sean or Andrew, do you see any circumstances or where it goes beyond that?
I see it advertised on social media or transaction coordinators, and I don't know really what their business is, where they're saying they can handle more than what I in my practice, what I see in other practices, what their role is. So there's the day-to-day business that I see, but on social media, I see them sort of raising their hands going, I can help you with that. I can do this. And it seems out of touch.
Yeah, so really it's going to depend on the role in the transaction. So, if I'm a buyer of real estate, and I'm actually purchasing real estate in my name or on behalf of my LLC, and I'm not being, compensated by the LLC to do it, I can put a purchase contract together. And, so I can act as a principal in a transaction. But if a transaction coordinator is going to act in the role of a transaction coordinator and transaction coordinator only, and be, compensated to act in that role, then in that case, they are, they cannot and should not be compensated for preparing legal documents. I mean, because that's outside of the scope of, what they would be authorized to prepare in that capacity in the transaction.
Interesting. So it's really what it really seems to me to come down to is a misunderstanding of where the line goes from administrative coordination to the practice of law, right? And if you're not a practicing lawyer, those terms might be opaque and almost difficult to understand, but they have real world and significant consequences.
So Andrew, last question, when should somebody, so for our listeners, when should somebody seek the advice of an attorney in a real estate transaction?
Right now. Call me. It's 555. It's, it depends on what it is, so let me back up. When should somebody seek the advice of a transaction coordinator? So my perspective is a little different, and I occasionally catch some flack on this, is, some newbie that's just starting off in investing, is told that they need to build this team. One is we're not a team. As an attorney or title company, they're not taking a percentage of your profits. They provide a service. They're service providers. So are the transaction coordinators. If you are going to use them, you pay for their services. You have them run title, you pay the title company to do that. You have the transaction coordinator. They're coordinating the transaction, whether it closes or not, you need to pay them. So the question is, somebody just starting off, if you're too busy on your 9-to-5 job, maybe you do need a transaction coordinator to help facilitate everything. If you're just starting off, make the phone calls yourselves. Do you need a transaction coordinator up front? Maybe not. I see it more used for those people that have a volume and to keep up with all their different transactions, whether it be with one company, multiple title companies, whatever it is. When to seek the advice of an attorney? If you've got questions and you're not 100% sure about what the hell you're doing, whether it's forming an LLC, did you form it right? Did you file all your paperwork in Arizona or Wyoming or Delaware? And now you're a foreign LLC when you're trying to buy, a property in Minnesota. What's the tax implications of that? Do you talk to an attorney? Do you talk to a CPA? But, the contract, forming it, is the contract sufficient? Are there terms that I need to be concerned about? I've been asked about a fence agreement, that's an easement on the property, whether or not that's going to impact the buyer's use of that property. You're not going to go to a transaction coordinator for that. You're not going to go to a realtor for that. These are things that you go for legal advice. Go to an attorney. It's really defining that. And then at least in Georgia, you should be going to the attorney, I always say from the very beginning, touch base. Hey, I'm going to do this transaction. Is this the kind of transaction that your office handles? What information do you need from me? Is there a problem with this contract that I'm using, that I typically use in Alabama? Can I use it in Georgia? That kind of thing.
Right. And to further your point, that's exactly it. So when I was saying, well, if I'm a buyer and I'm going to, prepare my own contract, okay, but your contract from one state may need to be revised to comply with the laws of another state, right? So you should always, if you're going to use a form and you're going to, do it as a principal in the transaction and prepare your own forms, you should have that form reviewed by an attorney in wherever the property is located, and make sure that it's complying with the local laws. And too often I think that's not happening. And so, yeah, that's a great.
And there's the standard practice of a real estate transaction, which I think varies certainly from state to state. I heard somebody the other day talking about, closing in California, and, it's like, oh, well, we're opening escrow and on Thursday, and, being in Georgia, I'm just like, what the hell are they talking about? But we're also a state that's, a good fund state. I guess there's differences between, a dry funding, wet funding, all that kind of stuff. I always tell people, for a closing in Georgia, the buyer and seller show up at the same time. The buyer has a suitcase full of money and the seller is ready to sign all the documents, and they do it at the same time, with the money going to the attorney that disperses it between the parties and everywhere else. I'm tired of seeing, buyers that are just like, well, okay, I'll get you the money, try to get it today. You haven't wired it. You got your documents 3 days ago. You knew you had to bring $50,000. Why are you struggling on your phone to send out a wire? Those kind of things. Or, I guess one big question that's a national question is earnest money. Is it required to make your contract legally binding? I don't know how it is in Arizona, but you don't need earnest money in Georgia. There's a spot for it, I'm sure, on every contract, but it's the interpretation. What if there's no earnest money? I got half a dozen transaction coordinators probably going to tell me that it's not a valid contract. Well, yes, it is in Georgia. So.
Well, and the flip side to this entire inquiry about when you should, as an investor or a buyer, seek legal advice, the flip side of this question is to the transaction coordinators or service providers. When are you engaging in the unauthorized practice of law, right? So if you don't fit within what's allowed with as the practice of law, in other words, you are a licensed attorney or you fit within one of those professional exceptions that they've carved out for you, that is the unauthorized practice of law. Now, there is not an ethics board that will pull your license like they will do that to the attorneys, because you're not acting under one. But that is a problem. That is a violation of the law, and something that should ultimately be avoided at all costs. Well, Andrew, we've come to our time. Thank you so much for taking the time to be with us. We appreciate it. Tell our listeners how they can find you and connect with you.
On the internet, on the web. You'll see me in all these social media groups in real estate. Feel free to reach out, or you can certainly touch base on our website, gurveylaw.com.
All right, gurveylaw.com. Andrew, thanks so much again.
Thank
Look
you.
forward to doing this again with you someday soon.
Anytime.
All right, you have a good one. With that, everybody, thanks for joining the show. Make sure to be with us tomorrow, 5 p.m. for the Creative Finance Collective, and we'll see you all next week.
Have a good day, everyone.